Good afternoon, everyone. Thank you for joining us on this lovely summer Friday. My name is Nick Kabat, and I'm a board member of the ACS New York Lawyer Chapter. We are thrilled to present today's discussion on New York State Rifle and Pistol Association versus Bruen, Second Amendment litigation 1 year later, along with our fellow ACS lawyer chapters from Nashville, Washington, D.C., Chicago, South Florida, and Oregon. Thank you for co-sponsoring this afternoon's event. Before we turn to today's talk, a couple of technical notes. We invite you to put any questions that you have in the Zoom Q&A function at the bottom of the Zoom window. I will be monitoring the Q&A throughout the event, and will do my best to ask questions to Professor Charles that I see in the chat as we go. Today's talk will also be recorded and later posted on the ACS New York Lawyers Chapter YouTube channel. So if you are unable to stay for the whole event and you really want to watch the rest of the talk, I encourage you to catch the remainder on our YouTube channel, ACS New York Lawyer Chapter. The subject of today's talk is the Supreme Court's decision 13 months ago in New York State Rifle and Pistol Association versus Bruen. When the Supreme Court issued Bruen on June 20th of 2022, it sent shockwaves throughout the legal community. Bruen was the Supreme Court's first decision on the Second Amendment in more than a decade, and only the third decision since the Supreme Court in Heller, well, second decision since Heller, recognized an individual's right to keep handguns in the home for self-defense. Bruen's immediate effect was to strike down New York's concealed carry permitting scheme. But Bruen also introduced a new test for gun regulations. Gun laws were now presumptively unconstitutional unless the law could be shown to be consistent with the nation's historical tradition of firearm regulation. The year following Bruen has seen courts grapple with how to apply that new test, including a new decision out of the Fifth Circuit that struck down a federal ban on firearms possession by domestic violence offenders. That case is now set up to be on the Supreme Court's docket in the upcoming term. Today, we'll unpack the Bruen test, how courts have applied it, and the problems it presents for Second Amendment litigation and firearms regulation going forward. Now, I have the honor of presenting our guest for today's discussion, Professor Charles. Professor Charles is a leading expert on Second Amendment law and an associate professor of law at Pepperdine Caruso School of Law. Professor Jake Charles, we are thrilled to have you for this important conversation. Let's get started. Jake, could you tell us a bit about yourself and how you ended up an expert on Second Amendment law?
Sure. And first of all, I just want to say thanks to you and thanks to ACS. I'm really happy to be here to be discussing an incredibly important issue, an issue that the Supreme Court is going to, like you said, take up again next year. So we'll have back-to-back Second Amendment rulings, which is pretty significant for what's been happening in the last 15 years at the court. So I got interested in Second Amendment law in particular because of one of my mentors in law school, Joseph Blocher, who has been writing on the Second Amendment since the day Heller came down. And he's truly one of the leading experts in the country on the issue. And I really got into writing on and thinking about it about 5 years ago when I went to the Duke Center for Firearms Law, which is the first academic center at a law school that's devoted to studying firearms law issues in the same way that there are First Amendment centers and institutions. This is the first one at a law school that studied Second Amendment issues. So I spent 3.5 years there as the executive director of the center. I've now been at Pepperdine for a full year, and in that time, I've been kind of focused very narrowly on the Second Amendment and firearms law and what the courts have been doing, in the Supreme Court in particular, as we built up to this decision in Bruen last year. So I study and write on firearms law and the Second Amendment, and more broadly, how the state regulates both public and private violence.
Still learning to come on off mute. Thank you, Jake. Why don't we turn to the Bruen decision itself? What were the issues before the Supreme Court in Bruen?
So there were two main issues that the court confronted in Bruen. There was the narrow question of whether or not the type of licensing law for concealed carry that New York had was permissible under the Second Amendment. And to kind of back up and explain what that licensing scheme was, It's important to understand when we're talking about concealed carry licensing, we're talking about the ability of a person to carry a handgun concealed outside the home. And there are generally throughout history 4 main ways that legislatures have regulated this kind of activity. There was what's called a no-issue regime, in which states banned the practice of concealed carry altogether. This was historically a very popular way that states would regulate concealed carry by just banning it. So many states didn't allow it for long periods of our history. Another way that states have regulated it is by what's called a may issue regime. And in that kind of regime, the state gives authority to the licensing official. So that's why it's called may issue. They have an ability to issue it, but they're not required to issue a license if a person satisfies certain discretionary criteria, like showing proper cause or justifiable need to have a handgun carry permit. Then there are what's called shall issue laws, and those shall issue laws are mandatory. They say to the licensing official, if these statutory criteria are met, you must issue a license. Those criteria are usually things like background checks and training requirements. Then the fourth kind of regulatory regime is permitless carry. So these are states that don't require anyone to get a permit at all before they concealed carry in public. So that's kind of the spectrum. New York's law at issue in Bruen was a may issue type of law. There was about 6 to 8 states at the same time that had this type of law. So it was a minority by the time of the Bruen decision, but historically it had been the predominant mode after the no issue requirements. So that was one question. Is this kind of law constitutional, or does a state have to remove all discretion from the licensing process? The other main issue that the court was confronting in the Bruen decision was what kind of test should lower courts apply when they're assessing Second Amendment claims? Should they do what they do in other areas of law, like First Amendment free speech challenges, and use intermediate and strict scrutiny, or should they use a different kind of test altogether? So those were the 2 main issues the court was confronting. Is this specific type of licensing law permissible, and what's the constitutional test that should be applied?
And so what did the court ultimately hold in Bruen?
So on those 2 holdings, on the whether the licensing scheme was permissible, the court said no, that licensing laws like New York's are unconstitutional because they vest too much discretion in licensing officials, and because they make it so that not everyone who is a law-abiding citizen who doesn't have a disqualifying conviction, for instance, can get a handgun carry permit. And the court said the Supreme Court doesn't allow this. And I should say this was a decision by Justice Thomas that was joined in full by the 5 other conservative justices on the court. If you know about the Supreme Court generally, it's very rare for Justice Thomas to have consequential majority decisions that are joined in full by other justices, because he has some idiosyncratic views on constitutional law. But this was a 6-3 decision in which Justice Thomas got all of the conservative justices to join. So they said that licensing law is impermissible. You can't narrow the set of people that get a handgun carry permit. If they are law-abiding, if they meet objective requirements in the statute, like background check and training requirement, you have to issue them a permit. So in effect, what the court did was say everywhere has to be at least a shall issue regime. You have to at least require the issue of permits.
So I guess
yeah.
On the concealed carry permitting, does that mean that a state can't ban concealed carry completely?
So there's a little bit of fuzziness here about whether or not the state can. New York bans open carry. And so the only way for a person to carry a handgun in public in New York was concealed carry. And so there's a question of, could a state allow open carry, which is, carrying a gun in such a way that everyone can see that you're carrying the gun? Could a state allow that and then ban concealed carry? Or does concealed carry have to be allowed no matter what the state's doing with respect to open carry? I think it was important for the court that there has to be a way to publicly carry a gun. And so if a state is going to ban open carry, then it must allow a form of concealed carry. So I do think that you're right, that it's now off the board for any state that doesn't allow open carry to ban concealed carry. So it has to be, it's possible that there could be a case where a state says, we want only open carry. But I think that's unlikely for what states are going to want to do in response to Bruen. So now, banning open carry or banning concealed carry off the table after Bruen.
And so what did the court install instead of a means end, or it seems like the court replaced a means end test? What did it put it in place instead?
It did, yeah. So, for those who are familiar with constitutional adjudication, it's kind of second nature for lawyers to think in terms of strict and intermediate scrutiny as the kind of constitutional tests for the exercises of fundamental rights. The court said in Bruen that test is illegitimate in the Second Amendment space. And the way that it critiqued that test was not limited to something unique to the Second Amendment or its history or its wording. Rather, what the court said was this is just judicial interest balancing. And judicial interest balancing is just replacing the balance that the framers of the Constitution struck for whatever contemporary readers and judges would want to put in place. So the critique was kind of trans-substantive. It seems like it would apply to any kind of uses of intermediate and strict scrutiny. And what the court put in its place was a test that is pretty narrowly historically focused. So what the court says is that now, if a law is implicated by the plain text of the Constitution, if a law regulates conduct that's within the plain text of the Second Amendment, then the government must show that the law is consistent with this nation's historical tradition of firearms regulation. So the court said there's this plain text kind of threshold inquiry, and then whether or not the law is consistent with historical tradition is going to determine whether or not it is constitutional. The court went on a little bit to talk about what that tradition looks like, and it discussed how courts would need to reason by analogy, and I'm sure we'll unpack the test a little bit more, but the kind of big takeaway is intermediate scrutiny, strict scrutiny, no longer permissible. Instead, what courts have to do is to look solely to historical tradition.
And is it overreading Bruen to think that they are suggesting at least some members of the court want to apply this history-only test, text, history, and tradition test to other constitutional rights, like perhaps the First Amendment?
Yeah, I think it's not overreading the decision to think that it might imperil the use of these kind of means in scrutiny tests in other areas of constitutional law. There was sort of nothing in the decision that made it seem like the Second Amendment was in any way unique. In fact, the court has gone out of its way over the last 10 years to say, we're not going to treat the Second Amendment differently than we treat other fundamental rights. And in fact, in 2010, in the McDonald decision, Justice Alito said it would be a second-class right if we applied a different set of rules to the Second Amendment than we apply to the other Bill of Rights guarantees. Now, I think one of the questions that arises is, but Bruen's test is not exactly the same as we apply in other areas of fundamental rights jurisprudence. We apply intermediate strict scrutiny. We have, since at least the 1960s. And so one question there would be, is this part of Justice Thomas's project to get away from these sorts of tests and get more towards a historical methodology for implementing constitutional rights more broadly? And whether or not those other votes that joined him in Bruen might join him in that project in other cases. I think that's kind of left up in the air, but I think we do see across a span of cases, free exercise cases, free speech cases, that the court is much more interested in kind of the historical inquiry and determining whether or not the history or tradition settles a constitutional question, as opposed to asking questions about what the government's interest in regulating is and how narrowly tailored a given law is to that interest.
Well, so I want to ask you more about this historical inquiry, but before we dive into that, you mentioned there's a preliminary piece, which is in Second Amendment cases, a court has to determine whether the Second Amendment actually covers the conduct that's being in question in the case. And clearly this includes concealed carry, since that was implied in Bruen. Yeah. But I guess the question is, what is included, what's not included? How have courts been trying to grapple with that question, and how have they proposed resolutions?
Yeah, so courts are, I think, struggling with this plain text inquiry, and they're struggling kind of at two levels. One level is, what are courts supposed to ask at the plain text stage? So Bruen says at some points that the question is whether or not the conduct is covered by the plain text. But elsewhere, it talks about the fact that in this particular case, the people who wanted to exercise the right, the plaintiffs there, were law-abiding citizens. It talks about the weapons they wanted to carry, said those were in common use by law-abiding citizens for lawful purposes and therefore arms within the Second Amendment. And it talks about their concealed carry and says that's within the meaning of bear arms. And so instead of just looking towards the conduct and whether that's covered within the plain text, it seems that Bruen is asking three kind of questions. Is the person covered within the plain text? Do they fall within the meaning of the people? Is the weapon part of the plain text? Does it fall within the plain meaning of arms? And is the conduct at issue covered? Is it either keeping or bearing, or maybe implicit or necessary to keeping or bearing? Some courts, though, after Bruen, have read the decision narrowly and said, no, we're only asking about conduct. So any kind of person who brings a claim, they're getting past the first stage, and we're only asking about conduct. Any weapon that's at issue, that's getting past the plain stage, and we're only asking about conduct. We're not asking about arms or people. Other courts, by contrast, have read the decision in what I think is the best way to read it, which is to say you have to satisfy all three of these at the plain text stage. We have to ask, is the weapon one of those ones that's in common use? And if not, that's just the end of the inquiry. If it's all courts have said machine guns, say, are dangerous and unusual weapons. They're not commonly possessed by law-abiding citizens for lawful purposes. So those are just out of the plain text wrong. They're just unprotected altogether. So that's kind of the threshold question, is what indeed are we asking? And then once courts actually do that kind of analysis, once they get past that stage of plain text is clearly implicated, what are we asking when we're asking plain text? Well, here courts are disagreeing about the level at which we're asking this question. So you could look at the words keep and bear and people and arms, and you could look at dictionary definitions and say, well, what's encompassed by those things? Some of those definitions are quite broad. In Heller in 2008, Justice Scalia, writing for the court, said arms includes all bearable arms. So kind of circular, but kind of bearable weapons for self-defense or offense. Right? That includes a ton of different things. If that is the only question we're asking about bear arms, then suitcase nukes, right? Those are bearable arms, right? They're weapons for offense. Those might be covered. Other courts are saying, well, we need to use a historical inquiry even in looking at the meaning of terms. And so we see cases in which courts are saying things like manufacturing a firearm. Well, that's not bear, that's not keep, so that's not covered by the plain text. And others are saying, well, there's no way to keep or bear an arm if you can't manufacture an arm, if you can't acquire an arm. So there's disputes over what kinds of things that are implicit or necessary to the plain text are included within it. And then there are disputes about things like what kind of people are undocumented immigrants, are unlawful drug users, are people with felony convictions, are 18 to 20-year-olds, are they within the plain text of the meaning of the word people? And Bruen doesn't give any guidance on answering this plain text prompt. It does give a little bit of guidance on the historical tradition, but it leaves absolutely nothing for courts to figure out how something is within the plain text. And that's led to a lot of divergent conclusions in the lower courts.
I assume this upcoming decision, this next term in the United States versus Rahimi, might provide some insight, if not an answer to this question. I want to make sure we talk about that later, but before we get there, can you help explain the historical inquiry and how the court applied that in Bruen and what that means for courts today in applying this historical inquiry, either at that first step or more broadly when it comes to reviewing a gun regulation?
Yeah, so here's the advice or the guidance that Bruen gave. And, I'll talk a little bit about how I think this was insufficient guidance, but here's what Bruen said. So what Bruen said was, again, plain text prong, and then if the plain text prong is satisfied, the government has the burden of introducing evidence sufficient to satisfy a court that the regulation is consistent with the nation's historical tradition. And it said that historical tradition doesn't mean that the government has to show an exact twin. It doesn't have to show that there was the same law or the law that looks really, really similar to the one at issue today. So take something like a restriction on large capacity magazines holding more than 10 or 15 rounds. The government doesn't have to show that kind of law existed in 1791 or 1868, but the government does have to show, Bruen said, a representative tradition, and it has to show something that is more than just a one-off outlier. So courts have been grappling with what do we do to look to this historical, or what does it mean to find a well-represented tradition in American history. Bruen said reason by analogy. So it said you don't have to find the same law, you can reason by analogy. And it said because reasoning by analogy requires tuning into something that's relevantly similar between two different objects, here are a few relevant similarity metrics. The court said, how much does the old law and the new law burden self-defense? So that would be one thing that courts should be looking to see if that's kind of similar between the two, the old law that the government's using and the new law that it's defending. The burden on self-defense is one metric. The other metric the court said is how the laws are justified. So was the old law, say, designed for a similar reason that the new law is designed for? Was it designed to prevent fires in buildings? And the new law was designed to prevent gun deaths? Well, those might be different kind of reasons. And so the court said that's one relevant aspect of what you're asking if something's relevantly similar. So with those two metrics, the court then marched through all of the historical examples that New York State provided in trying to defend its concealed carry regulation, and the court dismissed one after another as insufficiently analogous. The court said things that matter are also things like age. So an analog can't be too old. So laws from the medieval ages that regulated weapons in public, those were going to be too old unless the government had evidence they were continued into the common law of the colonies. And also laws that are too recent are not going to count as part of this historical tradition. So the court essentially said laws from the 20th century are off limits unless they are consistent with a part of an earlier tradition. So that really bookends the search between sometime between maybe the mid to late 1700s to the mid to late 1800s as the point in which the court is going to allow the government to introduce laws that the government could argue are relevantly similar to laws today. But in terms of how many laws are sufficient to constitute a tradition, Bruen said nothing, and lower courts have disagreed. In terms of what the government must show about the enforcement of these laws, the court didn't say, but it suggested at some points that some laws could be dismissed because there wasn't record evidence of how often they were enforced. It doesn't say kind of what the evolution of these laws matters for the constitutional analysis. And we see lower courts kind of splitting in all their ways in which they're trying to find what constitutes a sufficient tradition that can sustain a law today.
I know there was at least some courts that have hung their hat on this phrase in Bruen about 3 statutes and whether or not 3 statutes is enough. And it seems like there's a number of kernels throughout Bruen where the court is setting up a very high bar, an exacting standard for states that are seeking to justify any type of restriction on the use and carry of firearms. And what have you seen from your analysis of court decisions after Bruen about how courts are using those types of that analysis in Bruen to justify either upholding or striking down gun regulations?
Yeah, so I think that's exactly right, that there are some places in Bruen, not in its announcement of the test or its guidance on how to apply the test, but in how it actually analyzes proposed analogs in the concealed carry context that make it seem that the test is pretty strict. So it dismisses, for instance, a Texas state law that it said was analogous. And it even noted that the Texas Supreme Court in the 1870s had upheld this law twice. And yet the court said, well, that's an outlier. So we're not going to count that as enough to sustain New York's burden. It also said territorial laws. Well, we can't count territorial laws because those govern very small percentages of the population. So that can't suffice to show a tradition. And lower courts, depending on kind of the political valence of the case or the predilections of the judges, have latched onto different parts of the decision. So one judge in New York said, Bruen requires showing both that a law is well established and that it's representative. And the court there said, that means that we need to see both a number of laws across jurisdictions. So the court there said at least 3, and that they governed a sufficient amount of the population. So it said there, 15% is too small to constitute a well-established tradition, but 20%, that might be enough. So we see courts asking these kind of questions of how many laws are enough, but also what is the percentage of the population that they govern. And again, Bruen only offers the vaguest of hints by saying these are the things that are insufficient, or at least they were insufficient in this particular context, but it doesn't really say what are the things that are going to be enough to satisfy its own test. And so courts are all over the map on whether 3 laws are sufficient. One court said 7 laws is what you need. One other court said even laws in about half the states was not enough to satisfy the test. And there's kind of no consensus among the lower courts about kind of how to conduct this inquiry into the existence of tradition itself.
I see a relevant question, which is in the chat talking about Hawaii and their attempts after Bruen to restrict concealed carry, but focusing on sensitive places and particularly concealed carry on beaches. And the question is really about the potential success. And I think it's asking, what does Bruen say about sensitive places? And what does it mean for the historical inquiry to focus on places like beaches, which may not have been a major subject of regulation in most of the country at the time of founding?
Yeah, I think that's right. So there's an interesting way in which the Bruen decision interacts with sensitive places. And I should say, when we talk about sensitive places, what we're talking about is essentially a few lines from the Supreme Court's 2008 decision in Heller. And in Heller, what the court did was it said, our decision is not calling into question the constitutionality of certain laws. And one of the laws it listed there, it said, was laws prohibiting guns in sensitive places like schools and government buildings. So that was kind of the essence of what the court said there, and the totality of what the court said there about sensitive places. It did not say why that was justified. It only said our decision was not calling those into doubt. What Bruen says is, it says also that these kind of laws are permissible by the historical record, it says, but it lists slightly different places as represented in the historical record. It says legislative assemblies, polling places, and courthouses. But the decision in Bruen also says that the government can recognize new places as sensitive places where guns can be prohibited based on this analogical reasoning method. It doesn't give much more than these two kind of metrics of what's the burden on self-defense and what's the justification, but it says it does recognize that there are new places that can be deemed sensitive places. And the way the decision, I think, interacts with sensitive place law is if you think about the way that these concealed carry permits had worked in a number of the states that were enacting strict regulation, is that they would limit the number of people who could publicly carry. Those people had to show justifiable need or good cause or proper cause, as New York's law said. And so not everyone who wanted to get a gun permit could do so. Now, where Bruen requires that everyone who meets objective criteria in a statute must be issued a license, there are going to be more publicly carried firearms. And so one of the ways that states with strict regulation have responded is to enact new sensitive place regulations. So more places in which guns are prohibited altogether as a response to the fact that there are going to be more guns in public as a result of the ruling. So we see New York, New Jersey, Hawaii, California is debating about new places to restrict firearms. Bruen has said it's okay to expand the list beyond the historical categories that are set out in Heller and in the Bruen decision itself, but it has not said much about what is the rationale for courts to sustain these kind of regulations. And there's been a debate in the scholarship about what are the justifications? Is it protecting democracy? There have been some scholars who said, no, it's about whether the government is providing security in these places so that individuals don't need firearms. Is it to protect the vulnerability of the populations in those particular places? And we haven't seen courts kind of cohering around a justification, and Bruen, again, gave no guidance on how to conduct the actual specific inquiry into sensitive place expansions. But I do think that's going to be a significant area where we see courts grappling with what are the effects of the Bruen decision on this kind of category of places that the government can permissibly restrict guns to.
And again, it's going to be a historical analog. And so as Bruen has shifted this landscape of how state governments and the federal government are approaching the issue of gun violence, and approaching how they want to regulate the carrying and manufacturing and use of firearms, those governing bodies have to look to historical analogs that are from a time where different issues and different laws were in place, where Bruen was not the law of the land at all. And so they're drawing analogs, it seems like, from a historical basis that is completely distinguishable from the outset. And that presents a different challenge.
Yeah, that's totally right. I mean, one of the examples that commonly comes up is, what about guns on airliners, right? There are no airliners in 1791. And what is the analog to an airplane today? Is it a carriage? Is it horseback? There was no public transportation. There was very few of the private transportation that we think about today, and government was not regulating in the same way that it was regulating things today. And so that kind of question poses a lot of difficulties. And I think that's why one of the things it turns on is what's the justification or rationale for allowing the government to restrict guns in these places? Because the metrics that Bruen announces also are not extremely helpful. If you think about what the burden is on self-defense in a sensitive place, no matter what the place is, it's absolute, right? If you can restrict guns in this place, if it's okay for the government to restrict guns, then nobody can have guns. And so the burden on self-defense is the same no matter what kind of sensitive place you're talking about. And the justification is often going to be the same as well. And that's why a lot of it turns on how a court is characterizing that justification. Is the justification just trying to decrease the number of people who are hurt or killed? Is the justification that the government is trying to protect and promote the public peace, just a sense of well-being and safety? Is the justification that the state is trying to safeguard channels of democracy? So that's why we might see polling place or legislative assembly restrictions. And at what level of generality should a court view those? So is a modern restriction on guns in a legislative assembly today, is it justified based on those same grounds? Or is the current existing restriction on guns in Times Square, is that consistent with a historical regulation restricting guns in fairs, markets, and other public places? And courts so far, other than a few cases in New York, are upholding lots of sensitive place designations.
And so I guess you pointed this decision in New York. Which decision is that, and what did that court hold about sensitive places?
Yeah, there are a couple different decisions in New York that are about New York's post-Bruen law that changes the concealed carry requirement and that also designates new places as sensitive places. One decision that had kind of three different iterations where the court initially dismissed the case on standing grounds, and then granted a TRO, and then granted a preliminary injunction. So three kind of sets of opinions. That case was called Antoniuk. So in the Antoniuk case, the court there initially, even though it dismissed the case on standing grounds at the very beginning, included what it called 20 pages of judicial dictum. And it said there, New York just bans too many places from carrying guns. And essentially, I would have struck down the whole statute on sensitive places. When it finally got to analyzing the particular places individually, the court changed its mind on a couple different provisions as it went through the iterations of different series of rulings. But it said some things that I think sound strange to our ears. So it said things like, okay, there's a history of regulating guns in schools. So that means that New York can regulate guns in schools. But it said the government cannot also regulate guns in summer camps because there's no regulation that's similar enough in history to summer camps. And I think to most of us listening to that, we say, why would this tradition of regulating guns in schools not also justify regulating guns in summer camps? Court also pointed to the fact that there were almshouses in 1791, and there weren't restrictions on guns in almshouses. So maybe today restricting them from certain kind of health facilities or medical facilities is not going to be constitutionally permissible. So that court did go through a lot of the analysis, but I think some of the conclusions it reached in those cases were kind of bewildering if you're asking about the question of what's a relevant analogy as opposed to was there a historical twin that Bruen said is not required.
So I saw in the chat another question, which is about whether or not the analog for an airline is a ship. And I guess when the question becomes for states, do they have to constantly come up with new analogs, and you're, just tossing spaghetti at a wall if you're a state that wants to ban, for instance, guns from being carried in summer camps, to find an appropriate historical analog each time. Just pass the law again, and if it's not ships this time, do I find another historical analog and try that? Or are we going to see the Supreme Court have to come up with a long list of appropriate sensitive places, and then that's the end of it?
Yeah, I think this is one of the key questions about how this sensitive place doctrine evolves. I think it would be bad if it evolves just place by place, just ticking off places that are, this is in, this is out, this has an analog, this doesn't have an analog. I think what's the better approach, and what the court should ultimately do is say, what is the principle? What is the underlying principle that lets government regulate in these places? Or what are the principles that lets the government regulate in these places? And if the government can regulate to protect channels of democracy, if it can regulate to protect the vulnerability of people in certain populations, things like that, if those are the justifications, then instead of looking for precise replicas in the historical record, is a ship more like an airliner today than a covered wagon would have been, say, then we're asking questions not about what specific sites are similar, but we're asking questions about what were the types of regulations on places that were meant to protect, social discourse and social well-being, and those kind of regulations today. And I think there's a corollary question, like, does it leave open enough channels for the exercise of self-defense in other places? Or, are there some complaints about the comprehensiveness of a list of sensitive places? Each one maybe on its own could be justified, but if the government's restricting too many places that a person can carry in public, maybe that's a de facto restriction on public carry altogether that might be problematic.
This seems like a particularly thorny, it's going to present a lot of thorny legal issues. I guess one I want to shift to is this decision in United States versus Rahimi.
Yeah.
Which my understanding is that the case dealt with a ban on possession of firearms by someone subject to a domestic violence restraining order.
That's right.
And in the history of that case, it was pretty jarring. The defendant in that case, it's a criminal case, as I understand it, had been found to have been involved in at least 5 different shootings, while being subject to a domestic violence restraining order for physically attacking his ex-girlfriend. But the Fifth Circuit nonetheless found that the ban on possession of firearms is unconstitutional. And now that case is set to be argued before the Supreme Court. And I'm wondering, was that result surprising to you? And what did the court's analysis say about Bruen's historical tradition test?
Yeah, I think it was a little bit surprising because before Bruen came down, there were a number of us who advocated that the court should not dismiss the prior framework that had been used in the courts of appeals. This was it was called the 2-part framework, but it essentially was asking questions about is something within the scope of the Second Amendment, and then if it is, does it satisfy some form of means in scrutiny, intermediate or strict scrutiny? And that test, although it was criticized in lower courts, it was consistent with the way the courts are doing other constitutional rights. And one of the fears that many of us had about a solely historical inquiry was exactly this issue. What do you do with domestic violence, right? There were not laws that disarmed domestic abusers in the founding era. There's kind of dispute about how seriously domestic abuse was taken in the founding era, certainly. But one thing seems pretty clear is that it was not a woman's right to be free from abuse from her intimate partner. If anything, there was some state regulation of a husband's being a kind of poor head of the household, but more often there was kind of protection for the husband to be the head of the household and to, quote, chastise his wife when she was acting in ways that were somehow disagreeable to the husband. And so since we don't see laws even protecting women who are abused, then we're of course not going to see laws that are taking away the guns of the people who abuse them. And what you do with the fact that there's this missing history there on the subject of domestic violence is, I think, really hard for a historical analogy test like Bruen's test. You can do what the Fifth Circuit said and say that this is an outlier that would be unimaginable to the founding fathers. Right? That's what the court concludes. It would be unimaginable to have a law like this. I think that's correct. It would be unimaginable, but that's a problem, right? That's a flaw in our history, not something that we want to make constitutional and say, therefore, we can't regulate for these interests that we see differently today. And so a different way to look at the historical record is to not be so narrowly focused on whether or not there were particular laws that disarmed domestic abusers. There weren't those kind of laws. Instead, what you could do is to look to what were the types of laws that disarmed people in the founding era. And some of those laws were based on a person being perceived as dangerous or deemed dangerous by a legislature or by a court. And if they were dangerous, then there was legislative authority to take their firearms away. Another justification might be there were laws that disarm people who might have been seen as irresponsible, or people who are seen as non-law abiding generally and not just in particular dangerous. And so that's kind of the dispute in most courts about these regulations over particular people, is whether or not there has to be a tradition of dangerousness, or if it could be more general irresponsibility or more general non-law abidingness. But kind of everyone had agreed prior to Rahimi that the dangerousness rationale was kind of the narrowest rationale, that it would allow the fewest regulations, but it seems like it would still clearly cover people in Rahimi's situation who are demonstrably dangerous. And the Fifth Circuit just read the historical record a lot narrower. So it looked to particular types of laws that were introduced as analogies, and it said some startling things. So in responding to the argument that there were these group-based prohibitions on people who are dangerous or who are deemed dangerous at the founding, the court said, well, those laws were broad. They were about groups. This law, 922 G8, this federal prohibition, that's about particular people. So the broader law cannot serve as an analog to the particularized finding at issue in this case. I think that's kind of backwards. We normally think that a law that's particularized couldn't be the basis to support a group-based prohibition, but it's strange, I think, to think that a group-based prohibition couldn't serve to justify an individualized prohibition, which is narrower. But the court nonetheless dismissed those kind of analogs.
And
the court also made, go ahead.
Well, we're stuck in this group-based discussion where, even in Bruen itself, the court is pointing to Dred Scott and various other topics that are talking about bans on any African Americans possessing firearms or any Native Americans possessing firearms. And we're now in modern times pointing to those laws and fighting about, on both sides of this topic, whether you want to broaden the right or narrow it, how we can use those statutes to our litigation focused ends. And that seems like a problem that Bruen created, and it's bound to really reinforce the significance of those laws.
I think that's exactly right. So I have a piece coming out in the Stanford Law Review online about these, what I call these sorted sources in Second Amendment litigation. And it's asking this exact question, which is, what do we do with these kind of really awful laws that are part of our historical tradition? So I think it's best not to have a historical tradition test that requires governments to look to these kind of laws, right? It's strange to say that regulatory authority depends on the laws that were enacted when the law protected race-based chattel slavery. But nonetheless, I think within a test that requires a look to tradition, there's a way to look to these laws to see what was the understanding of legislative power, right? Was legislative power over groups that were considered dangerous at the time? And if there was an understanding that legislatures did have that ability, well, then we can reject their particular applications. We can say, well, they disarmed African Americans, they disarmed Native Americans, they disarmed Catholics, they disarmed loyalists, they disarmed people based on reasons that we would today reject for a whole host of reasons, including the 14th Amendment, right? We would reject the reasons that they did it. We would reject the people that they apply this principle to, but we don't need to reject the notion that government can disarm, consistent with the Second Amendment, people who a legislature deems dangerous. And this is something that Justice Barrett did when she was a circuit judge. So when she was a circuit judge in the Seventh Circuit, she had a long dissent in a case called Cantor versus Barr that dealt with the federal law barring those with felony convictions from possessing guns. And she said, here's this historical tradition, and we can extract the principle that the government can disarm people they think are dangerous without also adopting, say, the notion that, oh, a law that disarms particular categories who they disarmed in 1791 is also constitutional. No, those are no longer constitutional, but it's the principle that we can extract from it that dangerousness is the rationale on which government can regulate. So that was kind of her decision there that applied, I think, a similar approach that if we have to operate within a historical tradition methodology, then that's the best way to deal with these historical laws, is to say the application was odious and it's terrible, but it tells us something about what legislators had the power to do in 1791. And if we dismiss them altogether, we're missing an important part of what regulatory authority legislators have today to regulate guns.
Has the DOJ been focusing on that Amy Coney Barrett decision, Justice Barrett decision, in its briefing so far in Rahimi, or do you expect that it is going to feature in the argument in that case?
I do think it'll focus heavily on the argument. I can't recall how strongly the government is relying on this. I think it sets the kind of the narrowest view of what legislative authority would be, and that the government can win in Rahimi's case by saying, even if we adopt the most narrow view of what the historical tradition is, it allows disarming dangerous people. So I think it will come up heavily in argument and probably in the eventual opinion. Certainly we see states, California and New York, defending current laws, citing these historical predecessors that are these these horrible laws that we have in our history. And they will say things like, we expressly disavow the racist intent behind these laws, but we have to, because Bruen makes us find historical tradition, and this is indisputably part of historical tradition, that legislators had this kind of power, even though they applied it to groups that they were judging inaccurately.
Is this a way that lower courts are trying to, in essence, narrow Bruen from below?
I don't think that's necessarily right. I don't think that Bruen makes these laws off limits, right? If Bruen did, then we might see a lot. We might call this narrowing from below. So I think it's consistent with the way Bruen talks about the historical record. Like, as you mentioned, Bruen cites Dred Scott favorably for the notion that there was this protected right to carry arms in public. And so if Dred Scott's going to be cited favorably for protection of the right, it seems incongruous to say that these similarly odious laws that regulate the right would be off limits, though we can cite the laws for expansion of the right. So I don't think it's inconsistent with Bruen for courts to rely on these.
I know we're coming up on basically 12 minutes left. So if anyone has particular questions that they want to pose to Professor Charles, please put them in the chat. I'll make sure to ask them. But I do want to make sure we address the practical impact of Bruen. How have gun laws and the regulation of firearms changed substantively in the year 13 months now since Bruen was issued?
Yeah, so Bruen is having a pretty profound impact in the lower courts. So kind of just as litigation outcomes, and I can talk a little bit about a more practical impact, but for my research, I kind of did an empirical analysis of the 12 months of decisions after Bruen. And in those decisions, claims in civil cases were prevailing at about a 40% rate, which is like really surprising, I think, and higher than we see in other constitutional rights contexts. Claims in criminal cases were much less likely to prevail, as you might expect. But those were only 3%, right? So they were way less likely to prevail. But what we see is that lots of laws that either are newly enacted or that were long thought to be constitutional have been struck down. One example I give is there's a federal law that says if you are under an indictment for a felony crime, you cannot acquire a new weapon. You don't have to dispossess yourself, but you can't acquire a new weapon. Never before had that law been struck down. And after Bruen, there's either 5 or 6 lower court decisions striking that law down, saying it's no longer consistent with the Second Amendment. There's a dispute about 10 cases. They're saying it is constitutional, but we're seeing that type of case is generating a lot more invalidations than we had seen prior to Bruen. So the practical impact is that lots of laws are being struck down, which is a really big impact for the court decision to be having in its immediate aftermath. something we did not see in the immediate aftermath of Heller, where courts were not striking down a lot of laws initially. But I mean, just also as a practical impact, we see studies about the effects of concealed carry laws, and a lot of the empirical literature says that as you loosen concealed carry laws, crime and violence goes up. And so one of the practical effects of the Bruen decision might be that there are more people being shot and killed by firearms in public. We also know that firearms create much greater and bigger harms than just the number of people who are shot or killed, that it creates trauma for entire communities, that it affects educational outcomes, that it affects well-being more broadly. We see surveys of people who are afraid to go to things like parades and movie theaters for fear of mass shootings. So in many ways, it has a symbolic effect as well on the way that the court is privileging Second Amendment rights that can have effects on people far beyond those who are just shot and killed each year.
Has it changed how, I know a number of states have passed new legislation in the wake of Bruen, seeking to address some of the issues you pointed out, a fear that Bruen's new test will increase gun violence in their communities. And I'm curious whether or not that's, anecdotal, or there is a notable increase in the number of gun regulations being passed, or perhaps, restrictions being amended to be less restrictive in the wake of Bruen.
Yeah, so I think one thing that is significant about Bruen is that it served as a catalyst for both red and blue states. And what we saw is that red states used the decision to deregulate further. So even though Bruen expressly said a state can have a licensing law for concealed carry as long as it's using these objective criteria, we saw states in the aftermath eliminating the permit requirement altogether. So there are now about 27 states that have no permit requirement for concealed carry, as opposed to, I think, 2004, there were 2 states. So over the last 20 years, massive deregulation of concealed carry. And we see red states deregulating in other areas as well, eliminating other kind of requirements for carrying guns in public. In blue states, I think courts or legislatures are also seeing Bruen as a chance to respond to the decision with new regulations. So Illinois and Delaware both enacted assault weapons bans after the decision came down, and both those laws have been upheld in some courts, and there's one court that struck down Illinois' law. Both those are on appeal now. We see states like Oregon passing a large capacity magazine ban and restrictions and adding permit to purchase requirement. So we do, and as we discussed, New York and California and New Jersey passing or are proposing new sensitive place regulations. So we do see blue states regulating more in the aftermath of Bruen, and red states deregulating more in the aftermath, which I think just confirms the fact that this decision is a further kind of digging into the culture war and the ideological separation that we see happening across the political spectrum, where the red states are getting further and further from the blue states in terms of gun regulation.
I guess this leads into one of the questions from the chat about depoliticizing the Supreme Court, which I understand is getting at the fact that in 2022, you had 2 monumental decisions, Dobbs and Bruen. And I wondered if you could talk a bit about how these two cases that both approach and use historical tradition to reach very starkly different results. One taking away a fundamental right, one really massively expanding the scope of that right. And these being what are often described as hot button political issues.
Yeah, I think to me, some of the most cogent critiques of Bruen come from Alito's own decision in Dobbs, where he says the fact that this kind of conduct wasn't regulated doesn't mean that anyone thought it was a right that the legislator couldn't regulate. He says the fact that there are Americans in good faith who disagree with this issue so much means that we should return it to the democratic process, right? There are strong interests on both sides. There's no kind of indication that we have a power imbalance among the various actors. There's no kind of political dysfunction the court needs to step in to correct. And so this is an issue that's best left to legislatures and to democracy. Bruen does not do any of that, right? Bruen does not say, does not even acknowledge how hot button an issue this is, doesn't acknowledge even the compelling interest the government has in regulating to protect against gun violence. And it really expressly requires this inference that Dobbs very clearly says is impermissible, which is that if something was unregulated, then that means it was a protected right. And so the court in Bruen is requiring a government to come up with an analog. It's requiring a law, an actual regulation. And if there is not an actual regulation at some point in American history, then what Bruen says is it's unconstitutional to regulate in that way today. I think that's really problematic for some of the reasons Justice Alito cites, but also for some of the reasons he doesn't mention. We can think of any number of reasons why a legislature did not regulate. One, right, it just wasn't a social concern. There wasn't large numbers of people who were being killed by this particular way or this particular weapon, so the government wasn't regulating. Right, it could have just been politically unpopular, even though everyone acknowledged that the government had authority to regulate. It just might have been unpopular. And so there are a whole bunch of reasons we can think of why something wasn't regulated in 1791 that do not give us reason to think that those in 1791 would have thought it was unconstitutional for the government to regulate in that way. And Bruen really relies on this assumption that if something went unregulated, then it must have been viewed as a constitutional right. And that's the only way you can get to the notion that the government has the burden of putting forward historical tradition. Otherwise, a modern law is unconstitutional. And I think the comparison between Dobbs and Bruen, especially coming one day apart in 2022, is really stark in the way they view what it means to find silence in the historical record.
So with a few minutes that we have left, I was wondering if you could say how you recommend that courts, elected representatives, and people who are engaged in this issue and concerned about gun violence begin to work within the Bruen framework.
Yeah. So, I'll lay my cards on the table that I don't think Bruen's framework is a great framework. I hope eventually the court, changes the framework and recognizes the unworkability of it. I don't think that it spells the end of gun regulation. There have been lots of cases, as much disruption as we've seen, there's been lots of cases upholding gun laws under Bruen's framework. So one thing I think courts can do when they're working within Bruen's framework is use a high level of generality when they're viewing the historical record, as opposed to, say, looking at whether or not there were summer camp restrictions, to use the example we talked about earlier. Looking at what were the reasons that the legislators regulated guns in schools in the early 1800s, and those similar kinds of reasons can support gun laws today. So raising that kind of level of generality, which they're viewing history, is I think one thing that courts can do fairly easily within Bruen's framework. They can also just say that we're not going to require a superabundance of laws in the historical record. We're going to look to what kind of laws would have been enacted if this had been a social problem, or a historical tradition that suffices without showing more than half the states enacted some kind of law. Those kind of things courts can do consistent with Bruen. I think for legislatures, I think especially legislators that are considering new laws should now think about legislating a little bit differently than they had prior to Bruen. Prior to Bruen, the focus was on what does the empirical evidence tell us about, say, guns and domestic violence? And once we combine those two, we need to regulate to protect these kind of interests. Obviously, that's still important. You don't want to enact a law that's not going to be successful at decreasing violence. But now I think legislatures should actually legislate with a view in mind of what is the historical tradition that we're drawing on in enacting this kind of legislation. And they can do that by relying on or calling as expert witnesses historians who can talk about the tradition of regulating in the kind of way that legislatures want to regulate today, so they can establish that kind of baseline even before the legislation is getting passed. So those are just a couple of ways that courts and legislatures can deal with it. And then engage citizens. I mean, citizens can do the kinds of things they do when they disagree with Supreme Court decisions all over the place, that they can advocate for change, that they can file amicus briefs, especially for the lawyers on here. They can file amicus briefs, and they can do a whole host of other things to kind of decrease the power of the Supreme Court over these fundamental questions in democracy.
I see one question that just came in. Maybe we can spend quickly a minute on it, which is
Right.
The gap between historical tradition and social science research on domestic violence, gun violence, and how that's going to, what that gap means for gun violence regulation in general.
Yeah, so there's kind of a Bruen seems to say that empirical evidence is irrelevant, right? I think that is dismissing the empirical evidence too quickly, because Bruen says to focus on why the regulation was passed and how it burdens self-defense. And those, in effect, are empirical questions, or at least they can be answered through empirical research. We can say things like, why are guns regulated today to protect domestic violence abuse victims? Because here's the connection between guns and violence, right? That guns in an intimate partner situation increase the likelihood of homicide by 5 times, pointing to other statistics about women abused with firearms. And then how self-defense rights are burdened. You can talk about things like how often are guns used in self-defense? What types of weapons are used in self-defense? So there is, I think, room for empirical evidence to be used, even within the framework of Bruen that seems to dismiss the kind of means and scrutiny that's used in other constitutional rights. The court doesn't, I don't think, outlaw all kinds of empirical evidence that show why we are regulating guns differently today.
Thank you, Jake. I really want to appreciate, thank you for your time today. This has been a great discussion. And thank you to everyone who attended remotely and to our co-sponsors from across the country. I hope you all found it as illuminating as I did. As I mentioned at the beginning, a recording of today's talk will be hosted on the ACS New York Lawyers Chapter YouTube channel. Also, please be sure to stay in touch. Sign up for our emails at acslaw.org. Or follow us on Facebook or our YouTube channel. Thank you so much again, Jake. And
Thank you, Nick.
I hope everyone has a great rest of your day.
Thank you.